apresentar os nossos palestrantes em português, mas antes eu vou agradecê-los. Benedetta e Andrea, it's a pleasure for us. I want to say thank you. We are between friends here. We are all friends here, so you can feel this this kind of informality here. But it's a good opportunity for us to understand your system and to know our bar association here. I'm a formal director here, but we all participants of our bar association. So I want to say thank you in the name of our directory. And I hope to see you soon in the next IVA if the pandemic allows us. And I hope you stay safe in Milan, in Italy. Okay. So I will introduce you for the audience. Andrea Puccio, como Pedro falou, é advogado criminalista de um escritório renomado, conhecido em Milão. Conheci a Andrea nos eventos relacionados ao International Bar Association. É um advogado que tem uma experiência internacional, então é muito importante porque ele vai trazer uma visão para além do sistema italiano, também uma visão que transborda aí as fronteiras nacionais, sobretudo na Europa, em que há evidentemente uma união de países, e essa união faz com que as ações delitivas e a forma de repressão e todo o sistema seja também adaptado a essa realidade, o que é diferente da nossa, do que nós estamos acostumados. A Benedetta também, advogada criminalista do escritório do Penalista Associati, sócio do Puccio Penalista Associati, e também vai trazer para nós toda a sua experiência também reconhecida lá. Então é isso, eu desejo a todos. Eu vou devolver a palavra aqui para o Pedro e desejo a todos uma excelente conferência. Pedro.
Andrea, Benedetta, thank you very much for joining us. Thank you for the opportunity to hear you. And on behalf of the President Paulo, who is our Bar Association President, I would like to say that we are really excited with your presentation. It's up to you.
Thank you, Pedro and Adriano, for your warm welcome in this situation. I'm very happy to be here and to have been invited to speak about the Italian criminal law system. Very briefly, our speech will be divided into three parts. Firstly, I will speak about investigation stage and charging decision. Then Benedetta will speak about the preliminary hearing and the trial. And finally, I will close the topic addressing the issue of corporate criminal liability. So, first of all, the investigation stage, what can I say? I have to say, first of all, that when a public prosecutor in Italy or a member of the police becomes aware of the fact that a crime has been committed, he must begin his investigation. In Italy, and this is a very important point in my opinion, the public prosecutor has the duty, he is obliged to start the criminal proceeding and carry out the preliminary investigation. If a crime has been committed, he doesn't have any choice. He has to conduct the criminal investigation. Preliminary investigations, as you certainly know, may involve many aspects and activities. For example, inspections, searches, seizures, phone tapping, and gathering evidence in general. In this situation, we have to say that the investigation and the evidence gathered during this phase are strictly confidential. We can say classified. So all this information and the evidence gathered during the preliminary investigation cannot be disclosed at all until the formal conclusion of the preliminary investigation. So it has to be secret between the public prosecutor and sometimes the investigated party. But it cannot be, nobody can be informed before the formal conclusion of the preliminary investigation. During the preliminary investigation, the judge intervenes quite rarely, and the judge of the preliminary investigation controls, we can say, the activities carried out by the public prosecutor and the police. And unless the judge of the preliminary investigation has authorized it, nobody can be wiretapped or arrested. All measures in this phase must be adopted by the judge and not by the public prosecutor with an order. The judge also must publish a written explanation of his decision in order to explain to the investigated party and to his lawyer the reason of the decision, the judicial and the juridical elements on which the decision is based. We have to talk, in my opinion, about an important topic. The topic is the precautionary measures that can be adopted during the preliminary investigation against both the individuals and the companies. Precautionary measures can be adopted only if there is a serious suspect that the defendant, that the investigated party has committed a crime, a specific crime, and on the other hand, there is at least one of the following grounds for imposing precautionary measures. The first one is the risk of tampering with the evidence. The second one is the risk of fleeing. And the third one is the risk of committing serious offenses or similar crimes. So the reiteration. I want to be clear. The public prosecutor has to prove that a specific crime has been committed and there are a serious suspect on a specific person, but on the other hand, he has also to prove one of the three elements that I mentioned. With reference to the preliminary investigation stage, we can say that there is no real term for the conclusion of the investigations. When the public prosecutors deems that he has gathered enough evidence to potentially issue the indictment, he must serve a notice to the defendant and to his lawyers. An important topic we discussed with in the past with my friends Pedro and Adriano about this topic, and I think it's very important for you all defense lawyers. We have to analyze the issue of the defensive investigations, because starting from 2001, according to the Italian law, defense lawyers in Italy are entitled to conduct defensive investigation. We have specific articles. I'm not analyzing the specific articles of the the Code of the Criminal Procedure, but I can tell you that we as criminal lawyers can carry out different activities. For example, we can conduct formal interviews with related statements that have to be signed by the person interviewed and by the interviewing lawyer. We can also carry out informal interview with people, talks without records. Sometimes it is very helpful in order to know evidence and to gather evidence in advance before the trial. And then also we can gather statement, written statement by individuals after that we request as lawyers to this person to write a statement on a specific topic. We have some general rules that I think they are very important with reference to the defensive investigation. Why? Because unlike the public prosecutor, fortunately, I have to say in this case, fortunately, the defense lawyers are not obliged to disclose or to file the evidence that has been gathered. As you know, the public prosecutor has to disclose the entire evidence gathered during the preliminary investigation. The criminal defense lawyer is not obliged to do so. He can keep the evidence until he deems it is helpful or useful for his client. And in any case, the lawyer can choose or select what evidence to disclose regarding his client. Obviously, the lawyers, unless we can say he's out of his mind, will only disclose the evidence in favor and not against of his client. On the other hand, the public prosecutor should, and I have to say should, file all the evidence also in favor of the defendant. Let's pass very quickly to the phase of the stage of the charging decision. We said that once the preliminary investigations have been completed, the prosecutor has two alternatives: either to request the dismissal of the proceedings, and so he has to ask the agreement and the decision, the final decision, to the judge of the preliminary investigation. In that case, the proceeding will terminate. Or if the prosecutor intends to pursue the criminal action, he must notify the investigated parties, one or more, and their attorneys, of course, the conclusion, the formal document of the conclusion with the charging statement. The prosecutor must, in this case, when the preliminary investigation are concluded, must file the documents relevant to the preliminary investigations, completed in order for the investigated party and their attorney to review, to analyze, to examine all the documents and the evidence gathered by the public prosecutor and the police. In this case, the investigated party has 20 days to review, analyze, examine the documents, and of course, the investigated party can also request the prosecutor to carry out further investigation, or can also request to be heard by the public prosecutor. We normally, as defense lawyers, we are not very happy to have a direct relationship with the public prosecutor in this specific stage, unless we face a very specific situation, because we prefer to defend our clients before the judge, not before the public prosecutor, in specific in the white-collar crime proceeding, because we don't want to disclose the defensive investigation, and we don't want to disclose or to anticipate our defense strategy. After these 20 days, the prosecutor must arrange any further investigation, and then he can request a dismissal, or, as we said, exercise the criminal action and file the formal indictment. So the investigated party will become the indicted party before the judge, and he will have to face a proper trial assisted by the attorneys with a specific indictment that has to be very precise and very clear, because it will be the document on which the court will decide either to convict or to acquit the investigated person. So I will pass now the stage to Benedetta for the trial, and then I will, if I will have time, I would like to focus my very short speech on the corporate criminal liability, on white collar crime, because we have a specific decree. I think it could be very useful for you, also for the foreign and international multinational companies that operate in Italy. Thank you for the moment.
Thank you, Andrea. So the preliminary hearing judge, after receiving the request of the prosecutor, must schedule the decree, the hearing decree, and notify it to the parties. So I mean the indicted parties and any civil damaged parties, and their attorneys, within 10 days from the date of the hearing. The preliminary hearing, which is conducted in closed chambers, is aimed at verifying the correct exercise of the criminal action, and in order to avoid inconsistent objections or objections which are based on contradictory evidence. So the preliminary hearing begins with the appearance of the filing. It is possible in this stage that civil damaged parties ask in this stage for the return of amounts and or compensation for damages deriving from crimes. So in this case, the judge must evaluate if there are the formal and substantial requirements provided by the law. Once this preliminary stage is terminated, the preliminary hearing judge opens the trial, in which firstly the public prosecutor explains, so intervenes, explaining the evidence that he gathered during the preliminary investigation stage, and so the evidence on which the accuse is based. After this, the indicted parties can render spontaneous statements, or can ask to be interrogated. The parties, after this, will be heard in a specific order, so starting from the attorneys of the civil damaged parties, the attorneys of the civil liable parties, and at the end, the indicted parties' attorneys. All of these parties have the right to just one rebuttal. It's important to say that the conclusions of the parties are based on the documents which are in the public prosecutor's file. So the judge actually decides on the basis of the evidence, all the evidence which the public prosecutor gathered during the preliminary investigation stage, and on the basis of the other documents or evidence which the parties filed during this stage and that were allowed by the judge. Up until the conclusions are filed, the indicted party can ask to be judged with alternative proceedings. They have to be requested formally, and so the judge must verify if there are all the requirements in order to admit the person, the indicted party, to the alternative proceedings. And about this we'll speak later. Once the conclusions are filed, the preliminary hearing judge, if he deems that he has enough elements to decide, he declares the hearing concluded, and so he issues an order. At this point, the judge has two alternatives. The first one is to issue an order to proceed. The second one is to issue a decision that there is no reason to proceed. The judge issues an order to proceed if he thinks that the elements, the evidence gathered by the public prosecutor are enough in order to conduct the person to the trial. So there are sufficient elements grounding the charges against the indicted party. And so it's necessary to go to trial. On the other hand, the judge issues a decision that there is no reason to proceed if he thinks that the person, the indicted party, is innocent. So he deems that he's innocent, or the elements against him are contradictory, or lastly, the person, the indicted party, can't be punished, or the criminal action can't be pursued. In this regards, we must say that this second kind of decision, so the decision that there is no reason to proceed, are very rare. So in our criminal system, Italian criminal system, it's common that the judge issues an order to proceed. For example, the statistics of the Court of Milan show that the decision that there is no reason to proceed are just 1% of the total. After the conclusions, if the judge deems that he's not ready to decide because he doesn't have enough element to do it, he can obtain a new piece of evidence. How? First of all, he can ask the public prosecutor to recommence the investigations, so he can order to the prosecutor to gather new evidence, and in this case he schedule a new hearing after this. On the other hand, he can gather new evidence directly. So he can, for example, he can hear witnesses, he can call experts, he can ask for documents. So he by himself can gather evidence without the help of the public prosecutor. After this, of course, he declares the conclusion of the hearing, and so he decides. If, as I told you, so the common conclusion of the preliminary hearing, so if the judge decides to issue an order in order to proceed, he must indicate in the decree which are the elements on which he thinks that it's necessary to go to trial, and also he has to indicate the competent court which decides the trial. So the court before which will be the trial against the indicted party. After this, there is the trial. So within 7 days from the date of the trial, and this is a deadline that no criminal lawyer, Italian criminal lawyer, has to forget in any case, because it's one of the most important deadlines for a criminal lawyer. So 7 days before the scheduled trial, the party, so the indicted party, must file the witnesses list. So the list in which the criminal lawyer, and so the party, indicates the witnesses, the experts, and the parties investigated for related crimes that they intend to summon. In this case, in this list, it should be also specified the circumstances on which the people will be heard. About this, we say that each party has the right to request the summons of witnesses to confute evidence against them. At the first hearing, so 7 days after the filing of the witnesses list, the judge verifies the compliant filing of the parties. In this stage, the civil damaged parties, as we told before in the preliminary hearing, can ask for return of amounts and or compensation for damages deriving from crimes. And so also in this case, the judge, if there wasn't before the preliminary hearing, has to decide the admission of this party. After this, the judge allows the parties to speak in order to illustrate the preliminary issues of procedural nature. So in this first part of the trial, the lawyers, Italian lawyers, must evaluate if there are issues concerning procedural aspects. And so they must explain them now, except for 2 issues, which are the content of the file and the joining or separation of the proceedings, because these 2 can be illustrated even later. One of these issues can be, for example, the jurisdiction, if there is a lack of jurisdiction, or for example, if there is the nullity of some of the decree, for example. In this case, the parties don't have the right to rebuttal, so each party can speak just one time. After this, the judge has to decide, so he can't go on before taking a decision on the preliminary issues illustrated by the parties. For example, to let you understand what I mean, we can say that during this year, after the illustration of the preliminary issues, we obtain very positive decisions. In one case, the judge decided that he was not competent for the criminal proceedings, so he sent he sent the file. We say like this: he sent the file of the criminal proceedings, and so the criminal proceedings, to another judge of another city. In another case, the judge decided that to regress the criminal proceedings to the preliminary hearing judge, and so the preliminary hearing stage, for the nullity of the decree. And so in this case, there will be a new preliminary hearing stage. At the end of this stage, the judge declares open the trial. And so he hears in order, starting from the public prosecutor and the civil damaged parties, the civil liable parties, and the indicted parties, in order to illustrate the facts they intend to prove and the evidence that they intend to summon. The judge, in this case, decides to admit the evidence that that is relevant for the criminal proceedings. So it doesn't allow, for example, the evidence which are irrelevant. After this, the trial begins with the acquisition of evidence requested by the public prosecutor, and then the evidence requested by the civil damaged parties, and at the end, the evidence requested by the indicted parties. This is one of the rights of the indicted party, because in this way he can decide his strategy, defense strategy, on the basis of what the other parties before him gathered and so obtained before him, so that he can, for example, decide at the end not to listen, not to hear a witness which could be irrelevant or can maybe can't help, for example, the defense. So at the end of this stage, the judge can order, this is an important thing, so at the end of this the acquisition of evidence, at the end the judge can order the acquisition of new evidence that can be requested by the parties or that he thinks are necessary in order to decide. At the end of this acquisition of new evidence requested by the judge, it's a possibility. It's not common that judge asks for the acquisition of new evidence. At the end, the judge hears in order the conclusions of the prosecutor, the civil damaged parties, and the indicted parties. Even in this case, the indicted party is at the end, and it is right. So he can choose the conclusions on the basis of which the other parties said before the indicted party. The judge at the end declares the trial completed, and so he issues a decision. The decision is read during the hearing, and so it can be an acquittal, or it can be a decision not to proceed. The decision to not proceed is taken by the judge if the criminal action shouldn't have not been started or pursued, or if there are other problems, for example, if the indicted party in the meantime dies, or can be an acquittal. So in this case, the indicted party is proven innocence on the basis of the trial, or there isn't enough proof against the indicted party, or, for example, the proof of evidence are contradictory. On the other hand, the judge can issue a conviction if he deems the indicted party guilty. In this case, beyond any reasonable doubt. So this is written in our code. So it's important that the judge must be very, he has to think that the person is guilty beyond any reasonable doubt. After this, the judge has to determine the punishment, which is read also during the last hearing. Also, if there was the constitution of the civil damaged parties, he can also issues an order regarding the compensation or return of money deriving from crimes which was requested by the civil damaged party. Once the judge has issued the decision, the judge must write the arguments on which he decided in the conviction, which can be filed within a term that can't be more than 90 days from the hearing in which the judge read the conviction. This was about the trial. About the alternative proceedings, we can say that there are two main important alternative proceedings in Italy. The first one is the summary trial, which is conducted in closed chambers before the preliminary hearing judge. So in this case, the preliminary hearing judge doesn't have to decide if there are enough elements to go to trial, but in this case, he decides. So he takes the same decision of the judge of the trial. The difference is that in this case, the judge in the summary trial, the judge decides on the basis of the file of the public prosecutor. So he knows all the evidence gathered by the public prosecutor that were collected by the during the preliminary investigation. In this case, the indicted party can ask for a summary trial, conditioning it, condition the request with the acquisition of specific evidence. In this case, the judge must evaluate if the new evidence requested by the indicted party are relevant to decide and are consistent with the brief nature of this trial. This type of alternative proceedings entails a reduction of the punishment by 1/3. The other very common alternative proceedings in Italy is the plea organs, or according to the definition of the Italian Criminal Procedural Code, the application of punishment upon the party's request. This, like the American one, consists in a settlement between the indicted party and the public prosecutor for the punishment to be issued, which also in this case can be reduced up to 1/3. Once the agreement is reached, the indicted party file the request with the judge with the prior content of the prosecutor. The judge has to evaluate the settlement. So if he thinks that, if he deems correct the juridical qualification of the settlement and congruous the determination of the punishment that was indicated, he orders the application of the settlement by decree. If there are damages parties, in this case, they can't be helped, so the judge can't decide on the request made by the civil damaged parties, and so on this the parties should ask to the civil court. So I finished the preliminary hearing and the trial. So I would give the floor to Andrea to explain us about the corporate criminal liability.
Thank you, Benedetta. Pedro, Adriano, I don't know, it's 10 to 9, but if I have 5 minutes, I will, I can speak very briefly about the corporate criminal liability. I think it could be useful for you all. In Italy, the corporate criminal liability is regulated by the legislative decree 231, which introduced almost 20 years ago in the Italian legal system the concept of the administrative liability of corporations for the crimes committed by their management and their representatives, on the assumption that the relevant criminal conducts are committed in the company's interest. This is a very important topic nowadays in Italy, and the proceeding against the company doesn't differ from the one against the individual. They both will have to face a proper criminal trial before the same criminal judge, both the individual and the company. Pursuant to this decree, the following sanctions may be imposed on the company in case of violation of the said decree. There are many sanctions, but the main important ones, in my opinion, are the economic sanction. Then we have the confiscation of the price or of the profit of connected to the crime. Then we have the interdiction of the company's activities for a specific period of time. And then we have the prohibition to negotiate with the public administration. So currently, we have to say that many crimes are included in the 231 decree. I can say the most relevant. For example, we have the fraud against the state, we have the corporate crimes, we have the tax crimes, environmental crimes, health and safety crimes, money laundering, I mean, computer fraud, many crimes. So for each of these crimes, if the crime is committed in the interest of the company, both the individual and the company will be investigated and indicted, and they will have to face the same criminal trial. As I already said, a company is liable for the actions, for the conducts carried out by directors, employees of the company, but only if the crime is committed in the interest of the said company. The company is not considered responsible or liable if the individual that committed the specific crime has operated in his own interest or in the interest of a third party. In this case, we will have the individual investigated and indicted for the crime, but not the company, because there is no interest or advantage of the company. Finally, it is important to underline that not only Italian companies can be liable under this decree, but also foreign or multinational companies that operate in Italy with some employees, directors, branches, establishing a branch, for example, in Italy, can be held liable under this decree if the offense is committed in Italy. In fact, in the last few years, we have to say there have been several cases involving foreign and multinational companies that have been indicted and convicted for the violation of this decree. So it's very important to understand this specific decree and the corporate criminal liability that was introduced in Italy, because it can affect both the Italian and the foreign companies. So I concluded also this part very briefly. I hope it was helpful for you. Thank you, of course, for your attention. It was a pleasure for us, for me and Benedetta, to take part to this in this webinar with you all, and thank you again.
Thank you, Andrea. Thank you, Benedetta. Andrea, now I know why you invited Benedetta to join you. She did all the job alone.
I confirm it. I can confirm
As every day.
Thank you, guys. I will give the word to Adriano to finish our webinar, but I would like to thank you one more time. Thank you, Benedetta. Thank you, Andrea. Hope to see you soon.
Thank you, Pedro. Andrea, Benedetta, it's really a pleasure to host you here, guys. And I will finish this with a question, if you allow me. It's a question for Andrea regarding the criminal liability that you say in the end, that you said in the end. How the court, how the judges do or understand these misconducts? For instance, the company had an employee, and the employee do something wrong, like misconduct. I don't know the example, but he do something to increase his performance, for instance. Okay, to increase his performance and to earn bonus. For sure, this in the end, this will increase the profit of the company. So this is a good for a company. How could you separate the situation of the other one? For instance, when the CEO asks for the employee to do the same, how you can manage this thing?
Thank you, Adriano. This is a good point. Unfortunately, there is no separation at all between individuals and companies nowadays in Italy, unless, I mean, at least for the public prosecutors and judges, they believe that always, I mean, every time when a crime is committed in a company by an employee or a director, the crime was committed in the interest or at least in the advantage of the company. Exactly. So you will always have both the individual and the company indicted, because they will say, even though, or even if at the beginning the individual didn't carry out the action in the interest of the company, at the end of the day, when you look at the crime and the situation, you can anyway look for and let's say you can consider an advantage, a final advantage. So the public prosecutor will charge both the individual and the company, because the company anyway, at the end of the day, got an advantage, an economic one. So it is very, very difficult to prove the innocence of the company. It is a matter of compliance programs, actually, in Italy nowadays. You have to prove to having adopted in advance a compliance program, a formal and substantial compliance program that was adopted in order to avoid that specific crime. In that case, you can prove, you can try to prove the innocence of the company. But in the best scenario, you will anyway face a trial. Then you can probably get an acquittal. But I have to say that we don't have significant decision of Italian courts in which the individual was convicted and the company was acquitted. Either both the individual and the company were convicted or acquitted, or convicted or acquitted, both of them. Because as I told you, there is no big difference for the prime prosecutor and for the criminal judge. They know that the profit of the crime is inside the company, and they know that if they look for confiscation, they need to indict and convict companies, not only individuals.
Okay. Yeah, I suppose they don't need to prove that this decision became off the board of the company. And I think it will be, in my point of view, they must do this, because the interest, when you think about a company, you think about a board, you think about a decision of the high level of the company, not but okay, I think we have the same problem here in environmental crimes in Brazil. The companies can be declared guilty for responsibility of the environmental crimes. So we have the same problem here. But okay, thank you, Andrea, for your explanation, and Benedetta, and I hope to see you soon. And